Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to another podcast, now podcast number 122. And we're looking at three cases, of course. We've got one on the early conciliation process, one on the intersection of emails at work which are not work-related and whether there's a right to privacy, and a case I thought we'd start with, which is the legal impact of suspending an employee pending an investigation. And finally, a reward for sticking with me. I think it's a little while since I've banged on about concerts or so that I've been to see, so I'll rectify that at the end of the podcast. As usual, please don't forget, you can access the podcast. It's via iTunes. It's on our website, the Mayor Brown website. It's YouTube, the Twitter feed, where my handle is Nicholas ROBER11, and there are links to all the cases discussed. So first up, Agareo and London Borough of Lambeth. This is a case to do with suspension. I think it's an important case because it does indicate that perhaps some common practices by employers might be rather more troublesome and risky than employers might think. Well, the background is that this case, it related to an appeal to the High Court against a decision of a county court. The county court had rejected the employee's claim for damages, and the sad facts seem to be that the employee concerned was a teacher. She had responsibility for a class of 5 to 6-year-olds, and something seems to have gone wrong because 5 weeks into a fixed-term contract that was due to last for some 9 months, the employee was suspended because of something that allegedly happened in the class, and she resigned immediately in response to that suspension. The issue was whether there was any liability attaching to that suspension. Note, she was not expressly dismissed. She was just suspended. She did not have sufficient length of service to bring a claim for ordinary constructive unfair dismissal, and there doesn't seem to be any suggestion about claims for discrimination or whistleblowing or anything built into this. So she had resigned, that had been accepted, but she wanted to claim damages for the fact that she had been suspended, leading to her resignation. The factual pattern is difficult. It's quite difficult to work it out from the case report, and it's still fairly unclear. But it appears that there were concerns with this teacher's behaviour towards 3 pupils over events occurring fairly quickly in a 2 to 3 week period. The employee denied any wrongdoing, and the picture is pretty confused because the school, the line manager for the teacher in question, had investigated one of the earlier incidents and come to the conclusion that reasonable force had been used by the teacher concerned. Anyway, on the date of the third incident, which followed close on the heels of the other 2 alleged incidents of inappropriate behaviour by the teacher, the head mistress, not the line manager, the head mistress of the school wrote to her the following letter. I must write to inform you of a decision taken today to suspend you from duty on your normal rate of pay with immediate effect. This is a precautionary suspension in line with the disciplinary procedure, pending a full investigation into allegations. Unquote. I'm now going to miss out the detail of the allegations. The letter went on. Quote, the suspension is a neutral act and is not a disciplinary sanction. Full stop. The purpose of the suspension is to allow the investigation to be conducted fairly. Every effort will be made to complete the investigation as quickly as possible. You'll be informed immediately if, at any stage during the investigation, or if, applicable, at any stage of the disciplinary process, it is considered appropriate that your suspension should be lifted. During the period of your suspension, investigation into the allegations will be thoroughly investigated. As part of these investigations, you are invited to an investigation meeting, where you'll be given a full opportunity to provide your account of the alleged events. Following the investigation, a decision will be made as to whether there is a case for you to answer, and you will be informed accordingly. I assure you that the confidentiality of the process will be strictly maintained by management. Unquote. So there you have it. On its face, this looks like a reasonable letter suspending an employee following allegations of inappropriate force towards children in her class. What could the problem possibly be? Well, there are a few background facts that I haven't actually relayed to you as yet, and these played into the tribunal's decision. For example, the High Court judge on appeal decided the employee had already flagged to her line manager, who was not the headmistress, that she was having difficulties with behavioural issues allegedly exhibited by some of the children in question. Support mechanisms designed to help her that had been agreed in principle with the line manager had not yet been fully put in place at the time of the final incident. Given the nature of the claims, therefore, the judge had to focus on the suspension letter and the decision to suspend and whether it gave rise to a claim for damages. What the judge said about suspension and the nature and impact of the suspension, I think, is quite significant. For example, the High Court judge said that prior to the decision to suspend, the decision maker for the suspension, the headmistress, had not conducted any investigations with the relevant people, such as the line manager, in particular in relation to the fact that the employee, the teacher, had raised concerns, and that a support system was going to be put in place to help her manage behavioural issues. It was also the case the employee was not asked for her response to the allegations before she was suspended. There was no evidence or consideration given to any alternative to suspension before the decision to suspend was taken. And the judge was also critical of the fact the decision to suspend was taken on the day that the letter was written on the day the incident happened. So in other words, the decision to suspend was taken the very same day as the incident. The letter did not say who had taken the decision to suspend, and the letter did not explain why an investigation could not be conducted fairly without the teacher being suspended. Judge pointed out that the law on suspension, it is relatively clear, and it's been considered in a number of cases. It's been decided already in previous cases that being suspended from employment by your employer is not a neutral act in legal terms. It changes the status quo. It casts a shadow over the employee's reputation, and consequently, suspension should never be a knee-jerk reaction. The county court judge had said, when rejecting her claim, that the decision to suspend was reasonable because the school had an overriding duty to protect the children pending a full investigation of the allegations. However, the High Court judge pointed out that was not the reason given in the letter which suspended her. If you go back to the letter I read out earlier on, it said, quote, "The purpose of the suspension is to allow the investigation to be conducted fairly," unquote. On that basis, the High Court allowed the appeal, finding that the suspension had been a knee-jerk reaction. Therefore, it was a breach of contract and the employee was entitled to claim constructive dismissal. The judge also pointed out, of course, that if the employee's line manager had not been spoken to about her knowledge of the incidents, the earlier incidents, and the agreed support package was not yet in place, these too would amount to further repudiatory breaches. So, why is this case important? Well, first, in my experience, many employers do treat suspension as an automatic response to allegations of misconduct. Clearly here, having given a reason for suspension in the letter, it's very difficult for the employer then to try and rely on some other reason that it might have given at the time. So, be careful what reason you give for suspension, but make sure you have a reason for suspension. It's not the automatic knee-jerk reaction that the court found this was. The court did not say, I should point out, that in this case there were no grounds for suspension, or on which the teacher might have been suspended. They simply said that the grounds advanced in the letter of suspension were simply not good enough, and therefore this amounted to constructive dismissal. This brings me on to a second point. If you remember, the Supreme Court decided in the Johnson and Unisys case that it was not possible for employees to claim damages for an employer terminating a contract in accordance with its terms, but without good cause. The Supreme Court in that case said that took the view that a claim of that nature would be covered by the statutory unfair dismissal regime. And as such, the phrase has grown up, the Johnson and Unisys exclusion zone. In other words, claims for breach of contract, for example, for breach of the term of mutual trust and confidence, that might have existed on a termination on notice by the employer, are in fact prohibited by the courts because of the way the courts have interpreted the interaction of the breach of contract rules and statutory unfair dismissal protection. You cannot claim damages for the way in which you are dismissed under your contract of employment if the employer gives you proper notice, unless, of course, you can bring a claim for unfair dismissal. Similarly, you can't claim damages for breach of mutual trust and confidence for being dismissed without good cause. However, prior breaches which occur earlier on in employment and which are not connected with the dismissal might be outside the Johnson and Unisys exclusion zone, and they might give a claim for ongoing damages. Here, in this case, the employee is claiming damages for being suspended, rather than for being dismissed. Although the County Court thought this was an attempt to get round the Johnson and Unisys exclusion zone, the High Court was careful to make clear it was not determining that particular issue. That would await the quantum hearing. But the clear danger for an employer is that a wrongful suspension could create liabilities in excess of merely the individual's notice period if the employee treats the matter as a breach of mutual trust and confidence outside the Johnson exclusion zone and claims damages on an ongoing basis. All in all, the message is pretty clear. Tread carefully when suspending, be clear who takes the decision to suspend and why, and what alternatives are being considered. Well, that's the case of Agoreo and London Borough of Lambeth. Next up, Demota and ADR Network and another. So, this is an EAT case on the early conciliation process. No, wait, come back. This is important, I promise. The background is that the early conciliation process was put in place back in 2014. It remains entirely unaffected by the repeal of the tribunal fees system. Indeed, I think it's seen by many people as a very useful step in the tribunal process. Broadly speaking, employment tribunals should not accept a claim being lodged with it unless there's an early conciliation certificate which has been issued which contains the requisite information. The tribunal form submitted by a claimant must include an ACAS early conciliation number on it now in order to be accepted by the tribunal, and that in turn is only given out when the certificate is issued by ACAS. There are some isolated exceptions. I'm giving the overall picture here. Some of you with long memories may remember that back in 2014 we interviewed one of the senior ACAS officers connected with the early conciliation scheme, who was talking about its aims and approach, and he explained it was intended to be a very light touch process. The claimant can contact ACAS to get an early conciliation certificate and in that initial call make it clear that he or she has no intention whatsoever of conciliating. ACAS will then just issue the early conciliation certificate. Similarly, it's not possible to challenge an early conciliation certificate because the claimant did not conciliate in good faith or didn't disclose all his claims or anything of that nature. However, one of the rules is that the claimant, if submitting an application to ACAS to commence the early conciliation process, well, they can do it over the phone or by submitting a form. If a form is submitted, the rule is that there should be one form for each potential respondent. In this case, ACAS accepted an application for early conciliation but didn't push back on the fact that apparently the form put in by the individual covered two separate potential named respondents. They therefore issued an early conciliation certificate to the claimant, which also named both respondents in the same certificate. The two respondents took the point and argued that the claim was invalid and could not proceed because there had been no valid early conciliation certificate, and the employment tribunal agreed. Said that the entity named on the early conciliation certificate, i.e. the names of the two companies, was not a correctly named single entity, therefore the certificate was invalid, therefore the claim could not go ahead. Therefore, entirely unsurprisingly, the claimant appealed to the EAT, and, perhaps not unsurprisingly, the EAT agreed with the claimant. The EAT said the philosophy underlining the early conciliation process was an opportunity for conciliation to take place. It was light touch, and actual conciliation was neither obligatory nor could it be enforced on an unwilling party. Equally, the EAT made it clear it was not looking to encourage satellite litigation around the validity of early conciliation certificates. On that basis, the EAT took the view that ACAS had had a choice as to whether or not it would accept an application for early conciliation, even if the form named two respondents on one form. ACAS hadn't worried about the point here, they'd issued the certificate, and that was good enough. In line with earlier cases, it really does look as if the courts and tribunals are not interested at all in examining the validity of an early conciliation certificate. It's probably going to be some quite extreme facts before they're going to want to accept that they may need to do so. However, I still think this case and the two respondents on one form point is an important one to be aware of. If you're advising a claimant, it cannot make sense to run the risk that ACAS will spot the point, particularly after this case, when a form is submitted to ACAS, and ACAS will reject it, requiring the claimant to resubmit the forms. This could easily mean that the claimant is then out of time to lodge the tribunal claim subsequently, because the statutory extension of time for submitting tribunal claims only applies where the early conciliation process has been properly commenced. So, that's the case of Demota and ADR Network and another. Third and final case, Barbulescu and Romania. This too is a bit of a blast from the past actually. A year or so back we had the decision of the European Court of Human Rights on an application concerning Article 8.1 of the Human Rights Convention. And this is the right to respect for private and family life and home and correspondence. The court ruled against an application by an individual. In essence, what had happened was that the individual was claiming that the fact that his employer was able to dismiss him after having read his private emails sent by him at work was a breach of his Article 8.1 rights. Although the employer itself was not the Romanian state, that state had failed in its obligations to protect him when the Romanian courts did not sanction the employer for the dismissal. I remember at the time the judgment came out saying that the dissenting judgments had been rather more impressive than the majority judgment. Well, however he managed to do it, the employee has been able to appeal to the Grand Chamber of the European Court of Human Rights, and so 17 judges sat on this case to effectively hear his appeal against the initial rejection, and he won. Going into the facts in a little more detail, simply to be honest, because I think the Romanian employer's memo on the use of private equipment deserves to be immortalised. The employee worked for the company in Romania for 3 years from August 2004. The company's internal regulations when he joined did prohibit the personal use of computers, but there was no reference to the possibility that employees' usage would actually be monitored. He was asked to set up a Yahoo Messenger account for business purposes, which he did, and then in July 2007, the following information notice was sent by the company to the workforce. Quote, "Time spent in the company must be quality time for everyone! Exclamation mark. Come to work to deal with company and professional matters and not your own personal problems! Exclamation mark. Don't spend your time using the internet, the phone or the fax machine for matters unconnected to work or your duties! Full stop. This is what elementary education, common sense and the law dictate! Exclamation mark. The employer has a duty to supervise and monitor employees' work and to take punitive measures against anyone at fault! Exclamation mark. Your misconduct will be carefully monitored and punished! Full stop. No! Exclamation mark. The memo went on. Quote, "Because of repeated disciplinary offences vis-à-vis her superior, as well as her private use of the internet, the telephone and the photocopier, her negligence and her failure to perform her duties, Ms. B, was dismissed on disciplinary grounds! Exclamation mark. Take a lesson from her bad example! Exclamation mark. Don't make the same mistakes!" You guessed it! Exclamation mark. "Have a careful read of the collective agreement, the company's internal regulations, your job description, and the employment contract you have signed!" Exclamation mark. "These are the basis of our collaboration!" Exclamation mark. "Between employer and employee!" Exclamation mark. Unquote. Well, I think if there's one thing I'd encourage everyone to take away from this case is that we just do not use enough exclamation marks in our staff handbooks here in the UK. Anyway, back at the case. The company introduces a monitoring policy in that rather idiosyncratic fashion, and almost immediately, maybe it's not entirely coincidental, catches on to the fact that the employee's Yahoo Messenger account has got some personal emails on it. He was challenged on that, and the private messages which the company had found were all printed out and transcribed for use in the disciplinary process, so the company read them all. They cover messages of a personal nature between his brother and between him and his fiancée as well. But the employer dismissed him, having read them all, and dismissed him for breach of the policy prohibiting private usage, and the employee embarked on his crusade through the courts. Well, the Grand Court upheld his application on the grounds that the Romanian courts had not protected his convention rights. Article 8 was applicable to workplace communications, so there was a need to respect privacy, even in relation to computers and so on, belonging to the employer. And the court accepted that an employer cannot totally eliminate private social life matters in the workplace through policies, even though these can legitimately be heavily restricted. However, the court felt that there was not a balance, not an appropriate balance between competing interests here, the employer's interest and the employee's interest in privacy. Here the court picked out, for example, that although the employee was aware that monitoring was possible, he was not given any information about the extent of it, or that monitoring might involve actual reading of the emails that he was sending. Less intrusive monitoring might have served sufficient purpose. And it was not clear that the employer had in fact provided any legitimate reasons to justify the monitoring. Equally, the court felt it was lacking transparency for the employer to have had access to the contents of email traffic in these circumstances before inviting Mr. Barbulescu to a disciplinary hearing. So he won. But after all this, Mr. Barbulescu's remedy fell a long way short of his expectations, and he received nothing at all for any non-pecuniary damage, such as the break-up of his relationship with his fiancée, which he said was caused by his treatment by the employer. His pecuniary reward was minuscule. Well, in the UK, of course, we have a strict monitoring regime, and many of the court's comments about the need for a balanced and proportionate approach will be echoed in the provisions of the data protection legislation and the Regulation of Investigatory Powers Act. But overall, therefore, I think the case is unlikely to change practice significantly in the UK, other than the very rare case where an employee is unable to claim redress under British legislation and wants to rely directly on their convention rights. However, to the extent this case may raise the general awareness of the right to privacy at work, employers need to be careful about their justification for monitoring and the extent of that monitoring. So that's Barbulescu and Romania. And finally, I promised I'd say something about a concert I was at, actually Wednesday this week, first one I've been to for a little while, which a woman called Kate Ellis, who I didn't know much about her, but I'd heard a couple of her songs and I had a spare evening, so I went out and saw her at the Islington pub. And she was really good, so if you get a chance, do give her a song to listen. They're very pleasant. And just the sort of music I like. And seeing her live with, 30 or 40 other people, great fun. But yeah, check out her album on Spotify. I can't remember what the album itself is called, but her name's Kate Ellis, and definitely worth a listen. So, there we go. Thanks very much indeed. I'm going off to back to my desk to go and make repeated use of exclamation marks at all possible opportunities. Exclamation mark. And I will catch up with you again for podcast 123! Exclamation mark. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.